At the age of 18, the state of Utah deems a person a legal adult, even if that person is impaired either by a mental deficiency, physical illness, or disability and may not have the capacity to make or communicate responsible decisions for themselves. This means the person has the full legal authority to make their own decisions, and others do not have the right to make decisions for them. This includes decisions about healthcare, education, finances, and all other aspects of life. Many individuals with disabilities are able to make very good decisions for themselves, especially with support. However, some individuals can lack the ability to communicate and make responsible decisions for their medical care, shelter, safety, or basic care needs, to name a few. For these individuals, guardianship may be necessary for responsible decisions to be made on their behalf. If at some point the individual becomes able to make decisions and care for themselves, guardianship can be reviewed and revised to fit their circumstances. Here are a few frequently used terms and definitions related to guardianship. Petitioner is the person seeking guardianship and authority for an alleged incapacitated individual. Protected person, respondent, or person needing protection is the individual for whom you are seeking guardianship. Pro se or self-represented is self-representation in court rather than being represented by an attorney. Pro bono is the professional work done at no cost, providing services to those who cannot afford them. There are also types of guardianship. Full or plenary guardianship covers all areas of decision-making, including financial, medical, residential, education or training, healthcare and nutrition, personal care, and estate. Guardianship can be modified at any time. Considerations should include the individual's current maturity and growth. Limited guardianship applies only to those specified areas in the guardianship order. The individual retains all other decision-making rights. Utah law prefers limited guardianship. And finally, emergency guardianship. In an emergency situation, guardianship can be granted for a period of up to 30 days. For guardianship situations involving tribal or indigenous people, tribal laws may take precedence. How do I know if my youth needs a guardian? Asking the following questions can help you determine if guardianship may be the best avenue for supporting your young adult, or if an alternative to guardianship, like supported decision-making or power of attorney in a certain area, is a better option. Number 1, does the individual have the knowledge, skills, and abilities to have a job or attend school? Are there any supports available to them? Number 2, can the individual handle an emergency at home? Can they call 911 and communicate their needs? If required, can they leave the home independently? Can they do these things with some support? Number 3, can the individual speak for themselves in public situations and appointments? Can they do this with support? Number 4, can the individual make daily decisions and choices for basic needs? For example, getting dressed, making and eating food, personal hygiene, and laundry. Can they do these things with some support? Number 5, can the individual drive a car? Can they use public transportation? Are there others who can offer support in transportation? Number 6, does the individual know which bills to pay? How much? When? Can they pay them? Can they manage their money and contracts and resist fraud? Can they do this with support? Number 7, does the individual know which prescribed and over-the-counter medicine to buy? Can they take their medicine on time and in the proper amount? Can they make and attend a doctor's appointment? Can they do these things with some support? Number 8, can the individual understand what a dangerous or vulnerable situation is, and do they know how to navigate the situation? Guardianship may be granted by a judge after proof by clear and convincing evidence that an adult's ability to do the following is impaired to the extent that the individual lacks the ability even with appropriate technological assistance, to meet the essential requirements for financial protection, physical health, safety, or self-care? Can they receive and evaluate information? Can they make and communicate decisions? Or can they provide the necessities such as food, shelter, clothing, healthcare, or safety? However, some individuals may learn how or can already make some of these decisions on their own in a safe manner. Guardianship can and should be tailored to fit the needs of each individual person so that they may have as much self-determination and independence as possible. When seeking guardianship, it is important to respect the protected person's rights. The extent to which the protected person can make these decisions depends on their individual needs. The Utah statute and the Utah court's website emphasize that the protected person retains decision-making authority not given to the guardian or conservator, including decisions about his or her religion, friends, whether to consume legal substances, whether to marry or divorce, and other decisions, even under full guardianship appointment. The protected person retains all of the following rights: make or change a will or trust, marry or divorce, vote, practice religion, send and receive mail, email, and telephone calls, keep personal relationships with family and friends, be represented by an attorney, control personal spending money, consume legal substances, ask the court to end the guardianship or conservatorship, and ask the court to change the guardian or conservator or to change their authority. If any of these rights need to be restricted for safety purposes, restrictions need to be outlined in the guardianship documents. Every situation is unique. If you have questions or need additional help, please reach out to the Utah Parent Center and request to speak to a parent consultant, or refer to the guardianship section of our website where you will find our guardianship book and training videos. The information provided in this video is intended as general information only, based on the best information available at the time it was created. It should not be construed as individual legal advice.